Welcome to Finding Your Balance, a mental health podcast. My name is Tiffani Fritzsche. I'm a licensed mental health counselor. I'm joined with Kirk Fasshauer, licensed clinical social worker.
Hello.
Today we are going to be jumping into myths related to the Florida Baker Act. If you are new to us listening, welcome. We are so happy you're here. If you're returning, welcome back. All right, so Kirk, I think a lot of people get an idea of the Florida Baker Act, and some of those ideas are right, and some of them are not quite right.
Off. Right,
Yeah.
Right, exactly. So for those who are just coming into Florida, they hear Baker Act, and they're like, what is that? So technically, it's the Florida Mental Health Act. So every state in the United States has a law in the records or in the books that designed to look at patient rights and how individuals with mental health emergencies are handled and how they're supposed to be handled in facilities, where they go, who does the initiation of taking somebody into custody, and how that all works. So every state has something like that. For Florida, it is the Florida Mental Health Act. Now, we call it the Baker Act because it's named after Maxine Baker, who championed the cause back in the late 60s, early 70s. So the Baker Act, the majority of the Baker Act, as we know it, has been in place since 1972. Now, there have been laws in the books since the 1800s on how to work with individuals with mental illness. Major changes did not happen until 1972 with the Florida Mental Health Act. And so Maxine Baker helped champion the cause, and therefore we now call it the Baker Act in honor of her representation and championing of the cause in this situation. She has a great quote that I use when I do training on the Baker Act, and that is, in the name of mental health, we deprive them of their most precious possession, liberty. And so I usually start my talk off with that quote from Maxine Baker because I really want people to understand that initiating a Baker Act should not be something that is just just Baker Act. It's kind of glib and thrown off. This is a very serious act because what people who can initiate, and we'll get into that in a moment, who can initiate this law is, we are taking away somebody's freedom temporarily. And so when we initiate that Baker Act, people need to think about that in and of itself. Wow, what a message that sends. Because we Americans, if anything we value our freedom.
Yeah.
And to say, here's a law that says somebody who's qualified to do so can take somebody else's freedom away, temporary as it may be, that to me should be taken seriously and not so glibly, So that's why I like that quote, because it hits to the heart of what the Baker Act should be thought of and thought about before initiating. Because when we initiate a Baker Act on somebody, we need to understand we are taking that person into custody, taking their freedom away, their freedom of movement than anything else away, temporary as it may be. So when I say temporary, because that's what the intention behind the law was to, give people a structure of rights. They don't lose all their rights if you get Baker Acted. The big one being your loss of freedom. So you go to a locked facility for temporary detention and evaluation. And so that's the intent. So in the law, all that's required under the Baker Act law is that a licensed practitioner evaluate the person that was taken into custody, and they evaluate their level of imminent risk. So there's been arguments about, they get released too soon, or they're still having thoughts of suicide, and that may very well be. But this is not long-term treatment. It is a temporary evaluation. And there are other parts to the law that if we can't stabilize the immediate risk, then there's pieces in the law where we take people to court and do that whole process, which we'll get into a little bit here in a minute. But it allows for the temporary detention and evaluation. It allows for opportunities for people to voluntarily sign themselves in and involuntarily. It sets up involuntary criteria. So there's criteria for both. Haven't heard it more recently, but in the past I've heard people say there's no such thing as a voluntary Baker Act. Yes, there is a voluntary Baker Act. It's a status within the Baker Act. They're either voluntary or involuntary. And that allows for some interesting clinical movement if we use the voluntary as a sense of empowerment that the client has some say in their care and can sign themselves in. And there's certain criteria that need to be met there as well. It's not just, hey, I want to be here. So they have to go through a series of processes there. So in the state of Florida, there are 3 groups of people that can initiate. One being the courts. Family members can go to the courthouse, and it's usually through the probate court section. They go to the courthouse to state or give sworn testimony as to why they feel somebody needs to be taken into custody. What are the behaviors that are of concern? What other methodologies have been instituted to de-escalate or eliminate the risk here? Because that's one of the things they have an obligation. The courts have an obligation to look to make sure least restrictive means have been utilized prior to the most restrictive, being locked in a facility for a little while, and start the process. And start the process. So once it's done, sworn testimony is given. There's no fee, no court fees that are associated with this, so family members can go out and do that. But then they, once the magistrate or the judge recognizes that this person, yes, needs to be taken into care, it's now issued as a court order pickup. And it's issued, at least in Polk County, to the sheriff's office. In other counties, it might be different, but it's law enforcement essentially is given the court order to pick up the individual. And then they have up to 7 days, unless otherwise stated in the court order, in which to go pick up that individual. So they can go at 2 a.m. if they know where that person is going to be, to take them into custody because of the write-up or the testimony given, and then they're taken to a nearest receiving facility to where they can, do the evaluation part. Once that evaluation is over, they're released. And if they're no longer meeting criteria, they have to be released according to the statute. So courts are one way folks can get into it. Law enforcement is another way. So sworn officers can initiate a Baker Act. They do not have to, assess for least restrictive means. It's pretty much an immediate thing. If the person's meeting involuntary criteria, they're concerned for their safety, their risk. They're again meeting certain criteria. Do they have a mental illness? Are they capable of making an informed decision? Or are they a danger to self and others? There's basically 3 elements that need to be met in order for a Baker Act to be valid or to be initiated. And that criteria is the same whether it's through the courts or through law enforcement. All right? So they can do that. And then the third group is licensed professionals like you and I, Tiffani. We have some additional training, so things are slightly different where we have some choices to make. We do, again, like the courts, have to understand there may be least restrictive means, and we have to make sure those have been exhausted before going to this level. So we have that option to initiate or not to initiate because of some clinical work we might be doing. We want people to share some of the struggles they're having and not feel like it's a punishment. Right. And unfortunately, the flavor of Baker Act for many people is this is a punishment. It's really not meant to be a punishment. It's meant to be an extension of or part of care. Yes, more intrusive, more restrictive. Yes, it's a high-end kind of, or should be a high-end kind of level of care. And for some, it's the gateway into care as well. There's in such crisis that it's been determined how that's going to be handled. But as licensed professionals, we have that opportunity after we get licensed here in the state of Florida to initiate that as well. So we have to observe the behaviors. We have to provide a preliminary diagnosis of what may be going on here. We also have to give rationale when we write the Baker Act as to why we think least restrictive means are not going to work in these cases, or how they may have faltered in the care of this particular individual. And I know you help us out with the crisis response team in doing those Baker Act evaluations. And I kind of wanted to get some of your thoughts on your process as you've been asked to initiate or kind of evaluate somebody who might be needing that level of care.
Yeah. So whenever I'm working with an adult, it's going to be a slightly different kind of skill set than when I'm working with an adolescent or a smaller child. So for the adults, like you said before, they have the option of they can voluntarily sign themselves in at times. And so I want to make sure that they have a clear understanding, right? Their mental state is clear, it's not confused, and if they feel comfortable signing themselves in, I always like to use that shared governance of we're in this together. And so I'll usually start with, what do you think that you need to help you feel safe? And so I really try to start that framework already of, I hear you, I'm listening to you, what do you need? And depending on that conversation, I do my best to try to come up with a plan that we're both on the same page and we're doing this together. There are times when, because of that person's mental health in that moment, they're not able to make a decision about their safety. And when that happens, I do admit adults under the Florida Baker Act. For kids, it's a little bit different because typically they're coming in not by themselves. Usually they're coming in with a family member or maybe sometimes they come in directly from school. And what I try to assess straight from the beginning is the connection between that family system. So it's very clear from the beginning when they're in that room together, do they seem to be well bonded? Do they seem to have a good connection? Would they be able to follow a safety plan? If that kid was having maybe unpredictable behavior, does that caregiver have the ability to help them maintain that safety plan? So there's a lot of things that I look for whenever I'm assessing adolescents and kids that I might not look for in an adult, because sometimes the adults do come in with a support system with them. They've, a boyfriend or a girlfriend or a spouse, or even an adult, caring for an adult child. But whenever they're little ones or even teenagers, a lot of it also depends on the dynamics in the home. Are they going to be able to maintain that level of safety when they walk out the doors? And it's really hard sometimes for kids because, as you can imagine, sometimes they're resistant to talking to people.
Right, strangers in particular,
so
right?
You really have to really work hard in that interview to build some rapport. So all that we've talked about before as a clinician, the active listening, the rapport building that we teach people to do, for themselves and for their families, we use these skills every second during this assessment process. So for me, I look at that imminent risk as well. Like you said before, sometimes it can be frustrating for families because maybe they have a child or a family member who has unpredictable behavior.
Right.
And so maybe they were having unpredictable behavior and then they come to the unit to be assessed. And in that moment, everyone is regulated or they seem okay. And it can be very hard as a clinician. I can't make a Baker Act assessment based on what might happen in the future because, it's that imminent risk.
Exactly.
And it can be very frustrating for families when they come in. There's also, when you look at the Florida Baker Act, there's certain diagnoses that would not be appropriate for a Florida Baker Act to treat, right? And so, maybe you can speak a little bit about that because I know with kids, a lot of times what we see is maybe concerns about, I have a child who has autism. Could they be Baker Acted? Or you have a family member who has dementia. Can they be Baker Acted? What have you found to be the case in those situations?
Yeah, those are difficult situations because both can present, with some explosive behaviors. And they're actually exclusionary if they're in and of themselves. If it's about dementia, if it is about somebody on the spectrum, those alone do not meet criteria for Baker Act. Yet the family members caught up in those moments feel that, they're going to be a danger to the self or others, which is only one level or one element to the Baker Act involuntary criteria. And in both situations, dementia and autism spectrum, those actually putting somebody under a Baker Act and putting in a receiving facility can actually make things worse, not better. So those are things that are considerations when we look at that. And, I hear the frustration from family members because they've lived through the experience, and they bring them in to see you or me or members of my team, and they're like, this person needs to be Baker Act. Well, in some cases with the kids in particular, they look perfectly calm right there in front of us. Our hands are kind of tied a little bit. And yes, we do take into consideration some of the past behaviors, but we're looking at imminent risk. And I definitely get family members' frustrations, and it's like we can't handle this anymore. They need a respite of some sort. And, sometimes that's a difficult call. It really is. I don't necessarily like to just, I don't rubber stamp those decisions. I do kind of reassess myself in lots of cases, even with my own team. I mean, because we do a consult process where, I've got a crisis counselor who does the assessment. They get the preliminary information, and then they would call either myself or you if you're on call for us, and present the case. And then we'll talk to the person and do our face-to-face either in person or through telehealth, and try to figure out through our own assessment what's been going on, what's been tried, because we have that obligation to do so. And
it is really case by case because you may have two very similar situations come up. And so that's why it's so hard to give a definitive, this is going to be the outcome, because you really don't know. It's case by case. And a lot of it depends on the level of treatments they've tried. A lot of it depends on what treatments they're actively pursuing. Do they have an appointment tomorrow morning? There's so many things that factor into the decision that we make, because the weight of responsibility to take away someone's freedom is not lost on me. And I want to make sure that if I'm signing my name to a document stating that it's in their best interest that I take away their freedom in this moment, I want to make sure that I've done everything that I can to make sure that we've exhausted every least restrictive option first, because that is such an important thing and is the right treatment for some people, but it's not the right treatment for everything. Correct. And the criteria for involuntary, I've heard law enforcement say that, we've got a different criteria than you in mental health. And quite honestly, I look at them and say, no, it's no different. It's the same criteria. We have to go by the same stuff. One of the big differences, though, in how we do that process is the fact that we have to observe the behaviors. We have to have a preliminary diagnosis, and we have to, indicate why least restrictive aren't used. So in that sense, it's not a different criteria. It's a different, actionable process that we have to go through. Because my team's gone out to assist law enforcement in those situations, and they've been told, it doesn't meet our criteria. It's no different than yours. And trying to educate that whole process. So we work together, and we do work together well. Our partnership with law enforcement in Polk County has been really good. Polk County, Hardy County, and Highlands County has been really good with regard to they usually get called out first. And I think it helps that, so you especially have been instrumental in helping to partner with law enforcement with our CIT trainings. Right, CIT, Crisis Intervention Team Training. That's a 40-hour class for those that aren't aware of what that is. It's a 40-hour class for law enforcement on how to work with individuals with mental illness. And we actually we spend a half a day, about 4 hours or so, just covering their aspect of the Baker Act piece
for law enforcement, just so that there's a better understanding how to engage somebody in that particular crisis, part of what the whole class is about. And then really looking at the certificate they have to fill out and making sure they're filling out the right information and filling out correctly. So thank you for that feedback.
Well, it's been transformative because I've witnessed firsthand. So I operate a children's campus for Peace River Center, and we've had law enforcement come, to assist with different situations. And the quality of intervention has been exceptional because I think that the law enforcement officers who come, they obviously have taken the CIT training, but it becomes a therapeutic process. It's not a criminal process. It's not a punitive process.
Right.
It truly is another method of treatment. And I think that when you approach it that way, it changes the dynamics in the room.
Absolutely.
Right?
Absolutely.
And I've just seen even the kids and the family members, because, I'm working with children, and they've been incredibly responsive and receptive, and it makes it to where, okay, we're partnering with you, we're not coming at you.
Right. And, their training is to deal with more of the criminal element in our society, and that's a harsher approach than it would be with something like the Baker Act, which is a civil law. So we're asking them to assist in, providing help to somebody who's having basically a medical emergency, This is a mental health emergency, They need to, folks who are experiencing this need to get evaluated quickly. So when I teach this with law enforcement, I point out to them, the fact that they're temporarily taking somebody's freedom away. But not only that, what they're buying when they do a Baker Act is basically an instant ticket for them to see a licensed provider, basically a psychiatrist or a clinical ARMP, to evaluate that individual for their level of care need, and then going forward with that. So they're buying the evaluation. That's it under the law. And we have other things that we do. We've got discharge planning. We've got aftercare that we set up. We got family meetings, group activities on the units. So there's not just bring them to this place and they just sit around and wait for the evaluation. There are other things happening. But again, it's like an emergency room. It's a short stay. The longer term care continues when aftercare takes place. Especially if those who stabilize in that particular crisis and they get discharged back into the community. And then some people get frustrated with that process. Why are they turned around so quickly? Because under the law, it says that once somebody no longer meets the criteria, they have to be discharged. And so the licensed psychiatrist, the licensed practitioner is bound to do so. They need to release at that point. Now, if they don't stabilize, there's another whole process that takes place where a second practitioner is brought in to do a second evaluation. We call those opinions. And if it's determined at that level that, longer-term care is needed or an extended stay at the CSU is needed. And that's usually a short-term thing.
And when you say CSU, Crisis Stabilization Unit.
Correct. Thank you. And so once that's all put together, we hold court is held, and it is determined at the court level that care continues or does not continue. So basically, and we're talking a magistrate or a judge is present, the bailiff is present, we got a stenographer. I mean, the whole works are there. There's a defense attorney speaking on behalf of the client. There's a state attorney that's there representing interests in the state manner. And then we got a clinical team, usually represented by the psychiatrist, the attending psychiatrist, to represent the clinical vantage point here. They give testimony. The client gets an opportunity to speak as well. It's all part of due process, which is outlined in the law. And it's another major piece of the law to make sure that folks have a right to due process so that they aren't left in an institution and forgotten about as they were many years ago. And in this case, they get to look at, hey, Is this rightfully done? Do they have things in place and things like that get discussed at the court level? And then the courts really make a decision based off the information they have before them. They can either discharge. I've seen that a few times, that people get discharged right then and there. Sometimes we, the clinical team, are asking for an extended stay. So in that case, it could be something we're seeing if they will stabilize on a certain medication, and so we need a little bit more time to have the medication take effect and see if that's going to work. And then, of course, longer-term stay, which is probably more of a state-level kind of care, which is, when I say extended, we're talking maybe a year and a half at a state hospital, which is 5.5, 6 hours away from here. So they're taken so far out of their community and family members. The family members are important that they engage in the treatment process. Now, this is for adults. Mm-hmm. Juveniles, the Baker Act was written with adults in mind, okay? And so for many years, it's very adult-heavy and focused. The criteria is the same whether you're an adult or a child. There's some other things recently, more so in the last 5 years, where they've really kind of beefed up looking at how children are treated in this process. They're treated a little bit quicker in the fact that they need to be evaluated within 12 hours as opposed to 24 hours. They need to definitely have family involvement. The guardians and parents have much more of a say in this whole process as well, which is really a good thing. As long as there's no abuse and neglect going on from the family side, yes, it's really a good thing that they need to have family involved, and we really encourage that process, because the juvenile is going back to the family. And
that's why I think whenever we do our assessments, it's so important to identify from the get-go, is there a family connection here? Because we've talked about family systems all throughout the season of, if you take a child who is unhealthy and you put them in a system that's unhealthy, they're going to acclimate back to whatever system they're with. And so getting that buy-in from the family for treatment, for treatment recommendations, I think it helps to decrease the risk of recidivism, which is, going back into the unit, having another Baker Act.
Right.
I've really seen a lot of progress when the family is actively engaged in that treatment process.
Big difference, absolutely. When families are involved, it goes smoother, and sometimes families advocate in a good direction. There are also families that have agendas and want something else to happen, but legally it's difficult for the clinical team to move in some directions. So we do have to abide by the law with regard to that. When somebody's on the unit, like I said, they're not just sitting around looking at the wall or just watching TV. They're engaged in other activities.
And for kids, I would imagine that it's similar to the adults, but a lot of times on the kids side of the unit, they try to mimic just general activities of the day that a child would experience, whether at school or whether at home. So they will have some social activities. They have groups. They go outside.
Right.
But it's also measuring, are they able to maintain their stability in the midst of, transitions during the day? Are they able to engage independently? Are they able to engage in group activities just like you would at home and school? And a lot of times, yes, but sometimes no. And so I tell our families whenever I assess them for a Baker Act, I say, listen, we are so happy you're here, and we're so glad that you've reached out for support, and we don't want you to be here.
Right.
We want you to be home as quickly as you can. And so as soon as we can stabilize, that's what we want to happen.
Absolutely. And I know our little podcast here has this short, brief glimpse of what the Baker Act is about. We hopefully kind of dispelled some of the myths. I'm sure people still have more questions. And, you have our seminar. There is a webinar out there on Peace River's website and other areas with regard to what is the criteria? What does that look like? So one of the key things I would encourage our listeners to do if they're interested in this, most definitely look into those other resources. We can go on, and we probably will at other podcast moments where we will have further discussion of the limitations of the Baker Act and how maybe even it can be used therapeutically for those who wish to do voluntary as opposed to involuntary. So thank you for joining us for this little talk on the Baker Act, Florida's Mental Health Act. So thank you for listening.